Hello and welcome to this first in a three-part set of webinars on machine learning at the EPO. My name is Sam Jones and I'm a UK and European patent attorney at Gill Jennings Every. In this talk, we're going to touch upon machine learning at the EPO, how the EPO treats machine learning and techniques that you can employ in order to increase your probability of getting a granted European patent where you have an invention that involves machine learning. Over the series of these three webinars, we're going to be, first of all, talking about a brief introduction, what is machine learning. Then we'll move on to look at the European Patent Office guidelines on machine learning and have a look at a couple of examples of European patents that have been granted to inventions involving machine learning. Then look at discussions with inventors and how to draw out what you need from an inventor who has invented something in this space. Then there'll be an opportunity for questions, which you can submit, email me, and I will do my best to answer them and get back to you. So what is machine learning? So machine learning is a field of AI, artificial intelligence, but is usually what people mean when they're referring to AI. As you've probably seen in the media, things like that the term artificial intelligence is thrown around a lot. But in fact, it's we're a long way from general artificial intelligence, which is truly kind of the more kind of iRobot type intelligence that people are thinking of when AI is mentioned. What is actually being meant is machine learning, which is programming a computer to behave in a way that would be referred to as learning if the behavior was exhibited by a person or an animal. You, instead of explicitly programming the computer to perform a particular task, you train a machine learning algorithm so it progressively improves its performance at a very specific task. So it's a very specific tool. It's very good at performing a particular action, say recognizing faces and images, but it's absolutely terrible at anything else usually. So you really are creating something that is focused on one particular thing only, as opposed to general AI, which is a more kind of human-like intelligence where you have the ability to perform a number of tasks to a competent or indeed an excellent level of skill. Typically, the process of machine learning involves customizing a generic mathematical model using a set of input training data. And once the model is trained, you then apply it to a set of test data to provide a prediction or an output. So the EPO guidelines and some examples. First of all, just a quick rundown on the requirements for patentability. And these are true for any type of invention, not just those that involve machine learning. So first of all, your invention is going to need to be novel. And that means that it's got to be different in some way from everything that has gone before, which is referred to as the prior art. So that's things like earlier published patent applications or patents, journal articles, websites, magazine articles, even prior disclosures sort of in other forms like conference papers, conference presentations, that type of thing. So once you're novel, you're then going to have to show that you're inventive. And that basically means that the novel difference or differences are not obvious. And so, of course, the immediate question here is, well, what is obvious? What does that mean? And that's a term that's defined in patent law and interpreted by the Patent Office. So it's not the same as what a sort of technical expert may think is as obvious. But instead, the process you have to go through is to ask, when you look at what's in the prior art and you think about the common general knowledge of somebody with the right technical background, would that person, having access to all that information, would they have modified what's in the prior art to incorporate the novel feature of your invention in order to arrive at your invention? Would that have been something that they would have done without any sort of effort, just a sort of routine work? or would there have been kind of a sort of inventive spark, or kind of some sort of realization necessary in order to arrive at the invention? And in the former case, it's likely that the invention is going to be found obvious by the patent office, so you won't be getting a patent for it. And in the latter case, where some sort of inventive step is required, then that's when you're looking good and you are more likely to get a patent granted. And those two things are true for any type of invention, not just inventions involving machine learning. But with machine learning, we have a complication when we're looking at the inventive question. And that is that inventive step can only be acknowledged in Europe on the basis of technical differences. And so we now have a very obvious question. Okay, so what is technical? And that is something that is defined by patent law and by the patent offices, rather than a sort of more general definition of what may be considered technical. So in order to work this out, we look to a few sources, and one of which is the guidelines provided by the European Patent Office. And here on this slide, you can see a reference to a specific part of the guidelines, which is particularly concerned with AI and machine learning. And right off the bat, we're on the back foot with this, because the guidelines say that machine learning per se is a mathematical method, and mathematical methods are not technical. So straight away, we're in trouble, because a machine learning algorithm in and of itself cannot provide technicality. And what that means is you could have an algorithm that's novel and that's inventive, but because it is considered by the patent office to be inherently non-technical, because it is a mathematical method in their view, that means that you cannot gain the technicality that you need to get a granted patent. So what do we do about this? And what we do in practice is we link in the patent application the machine learning algorithm to something that is considered technical. And there's two main ways that this is usually done. And one way is to claim the machine learning algorithm in operation in a technical system. So for example, you could have a machine learning algorithm that's suitable for controlling an X-ray apparatus. And so what you would do when you were drafting your patent application is, instead of just describing your machine learning algorithm in a sort of more abstract way, you know, kind of data comes in and a prediction comes out, you would describe the machine learning algorithm as a component in, say, a controller for an X-ray apparatus. And you would say that some sort of data comes in relevant to the X-ray apparatus, and probably something like control signals come out of the controller in order to control the X-ray apparatus. And that's how you're able to get the technical character that you need for your machine learning invention. What you'll notice there straight away, of course, is that your patent, if it gets granted, is only going to cover your machine learning algorithm operating as a controller for an X-ray apparatus. So it is important to keep that in mind, because your machine learning algorithm may actually have a utility in other areas, but you're not going to get protection for that with your patent that's been described the machine learning algorithm in the context of an X-ray apparatus. So you may need to file more than one patent application, or describe your machine learning algorithm in a number of different contexts within one single patent application. What we would also try and do is think about what's the broadest context that we can provide that still has the necessary technicality. So we don't want to go too general and say something like controlling a technical system, because the European Patent Office is explicitly indicated in their guidelines that is not going to be enough to gain the technical character that we need. But you know, you can think with the X-ray apparatus, you can broaden a bit by sort of thinking along the lines of, well, let's say this is a controller for a device that generates electromagnetic radiation. And now suddenly you've also covered microwave controllers, for example. So, and what we can typically do, and this is always on a case-by-case basis, is examine the particular use for the machine learning algorithm that has been brought forward to us, and think about how we can generalize that such that we're still credibly linking it to a technical system, but we're not so narrow that you get less protection than is due for the invention that you've made. So the other way in which you can gain technical character for a machine learning invention is that you claim the type of data being operated on. And the EPO has given us some guidance on what they consider to be technical types of data and non-technical types of data. So you can see on this slide, one example of technical data is image data. So if you're going to claim your machine learning algorithm operating on image data, that's fine. You're going to get technical character because you've specifically said the machine learning algorithm here is operating on image data rather than some generic data. So that's all very helpful, of course. And if your invention happens to fall within one of these kind of predefined areas that the EPO guidelines set out, then that's great news because you can be confident which side of the technical line you fall upon. But what can we do for a kind of a general invention that may not necessarily have this type of precedent? And one of the things that we can do is look at the type of patents that the EPO is granting and the type of the applications that they're refusing, and to kind of build up a sort of a database of items that are considered technical and which are not considered technical. And you can see on this slide, I've produced a sort of the beginnings of this, where we've had a look through some of the patents that have been granted and some of the case law that's been generated, and tried to identify things that are on the right side of the technicality line and things which are not. So you can see on the left-hand side there, road traffic control, that's something that's considered technical. So just like in the example of the X-ray apparatus, if you link your machine learning algorithm to a controller for road traffic, that's fine. That's going to give you the technical character that you need. Another one, optimizing loads distribution in a network. So, perhaps controlling your server cluster so that you're loading the processes in an optimal way, or how you transmit data over a network, that type of thing. If you claim your machine learning algorithm in that context, you're very likely to get technical character and therefore much more likely to get a patent granted. Then looking at types of data. So we've got speech processing, audio, image, or video processing. So there, essentially, we're restricting the data that's being operated on to audio data, image data, or video data. Things like AI medical diagnoses and classifying patient medical state have been considered to be technical. So it may be, for example, a machine learning algorithm that analyzes an X-ray image in order to provide a diagnosis for a patient, or classifying patient medical state through things such as analysis of an electrocardiogram. So again, if you're claiming your machine learning algorithm in those contexts, that's going to increase your chance of success at the EPO, because you can credibly say that you have limited your patent application to a technical field. An interesting one is that we have seen some patents granted to improvements in methods of training AI. And this one I think is a little bit unusual because it sort of departs from what I've been saying previously to some extent. Because if you think about it, if a machine learning algorithm is considered to be a mathematical method, an improvement in the training of that is kind of an improvement in the training of a mathematical method. So it's sort of, you sort of think that looks like it may not be technical, but I'm pleased to say that in fact the EPO is showing signs that they consider training of machine learning algorithms to be inherently a technical thing, which is great. So moving on to the right-hand side, non-technical things, there's text document classification, which is I always find it somewhat surprising because it does mean things like natural language processing can have trouble at the EPO to gain the technical character that they need. You often find in this column things that are replacing the job that a human would typically do. So things like an AI financial analyst or an AI trader, selection of candidates for a job using AI, an AI auctioneer or an AI croupier. Those are all non-technical fields in which you can employ your machine learning algorithm. So if your algorithm is in one of those fields or is kind of seeking to replace something that a human would normally do, then that may make it more difficult to get technical character and therefore more difficult to get a granted patent. So again, looking at the patents that have been granted, that's very helpful because you can sort of flesh out the guidelines that the EPO has provided. But still, there's still a gap where we'd like to be able to work out for any arbitrary invention, which side of the technicality line am I likely to fall upon? Because of course, really speaking, you want to know that before you file a patent application, because you don't really want to spend the time and effort involved in drafting and filing an application if no matter how good your machine learning algorithm is and how novel and inventive it may be, you're going to fall foul of the technicality requirement and just have your patent application refused. So I've put up here a slide taken from an EPO talk, which was titled Patenting AI. And the bit that's interesting, I think, for us is the bit that's highlighted there in red and green, where the EPO is saying a useful exercise to go through is to ask the question, who would have come up with the idea to solve whatever problem your invention solved? Like where did the inventive concept, the kind of real core or kernel of the invention, where did that come from? And the EPO gives sort of two different types of person that could have generated this. And you've got on one side, financial expert or a salesperson or a business analyst. They're all going to be considered to be non-technical people. So if the kernel of the invention was generated by them, then that is an indication that your invention is likely to be found non-technical by the EPO. However, if the kernel of the invention was generated by somebody like a software or systems engineer, somebody who the EPO considers to be technical, then that's an indication that it's more likely that the EPO is going to find your invention to be technical. And this sort of way of thinking has been reflected in recent case law that we've been seeing from the EPO, where this idea of a business person who is a fictional legal person who knows everything about business but has very limited technical knowledge, this person is being created in case law in order that analysis that I was talking about on the previous slide can be performed. So the business person knows everything about business, and here I should make clear that the term business is a catch-all really, to include not just strictly business processes, but other sorts of administrative schemes or processes, and sort of generally anything that is considered non-technical. So it could be, for example, the business person is in fact a linguist who knows all rules to do with spelling, grammar, etc., but is not providing input on the configuration of a technical system. So the EPO has indicated that the business person knows of things like the internet and computers, but does not know how to configure them. So the business person can ask something like, can we implement this system using a computer? But they cannot say, I'd like it to be implemented in this particular way, and then provide some sort of configuration details of the computer. But what the business person can do is provide what's called a requirement specification, which explains from the business's side what the invention must do. So it could be, for example, if we're talking about an internal process to manage document flow, they might be saying, the business person may be saying, I need documents to be able to enter the business in this way, and I need them to be sent through the business so that it is able to be received by these people. And I think we should use some sort of computer system to do that. And that requirement specification is provided to a technical person or a person known as the skilled person to implement. And so the question becomes, is the kind of the core of the invention, the thing that really makes it something that's different from what's gone before, is that part of the requirement specification? Or is it something that once the requirement specification was given to the skilled person, in the course of their implementing a technical system, they actually encountered some sort of technical problem and overcame it? And the answer to that question will very often give a good steer as to whether your invention is likely to be found technical or non-technical by the EPO. So you can see that this analysis is very relevant for machine learning inventions, although it can actually be used for any type of invention where there is a sort of technicality concern. So I personally have been using this type of analysis a lot in my work, and I find myself always asking the question, where did the inventive concept come from? Did it come from a business person or a technical person? And that is a very useful and helpful question to ask, in my view, when trying to decide whether or not a patent application is worth filing for a particular invention, such as a machine learning invention. So that concludes the first part of this talk. If you'd like any more information, you can visit our website, send me an email, or feel free to connect on LinkedIn, and I will do my best to respond to your question.